This is case number 24-3984FH. Appearances from counsel, please.
Nate Carnes on behalf of the people.
Thank you, Your Honor. Patrick Cherry on behalf of Jeff Stark, who's present.
Do you have any amendments, corrections, or objections to make?
No, Your Honor.
How about you on that file alone?
Yes, Your Honor.
Yeah, go ahead, sir.
Beginning with page 1 of CFJ 145.
Yep.
Under education, it should reflect the same as the other PSI, which is a vocational certificate.
Oh, okay. Thank you.
Alcohol use from 1997 through the arrest date.
All right. Anything else in that particular report?
Your Honor, I think we'll have to deal with it in both reports. I'm turning to page 2 for the time of credit.
Okay.
We need to add a box for April 8th of 2025 through May 12th of 2025. April 8th is when the court revoked the bond in this matter. May 12th is the date that the contempt sentence began.
Yeah.
Occupation, janitorial.
Okay.
Monthly income, $800 a month. Religion, either Christian or Baptist. I didn't know what selections they have. Baptist would be particular, Christian would be general.
All right. Copy. Mr. Stapleton, did you catch that? Religion, just put down Christian. Let's be unified here together. All right. Let's put down Christian. Religion, Christian,
Okay.
Employment, janitorial, income, $800 a month.
Okay. The last one,
So
drug
with
abuse
$800 a month or 800 bi-monthly?
per month.
Per month. Thank you. All right. Yes, Mr. Chair.
And then drug abuse, yes.
And Mr. Carnes, when I asked you the question about corrections, I only talked about the 2024 report. Do you have anything to add to the 2025 report?
Your Honor, I do think it would be appropriate to score OV-19 at 10 points.
Mr. Cherry.
Thank you, Your Honor. I was not anticipating this objection to the scoring. Unfortunately, I'm left having to say I'm almost certain there's a case that was just recently decided about a defendant giving testimony at the interview, but I don't think it's necessary in this case because 2 paragraphs later, when Mr. Stark was re-interviewed at the same time, he admitted to pointing the gun at her. So I don't think there was an actual interference with the administration of justice. I think that this was...
And that's why Mr. Carnes, I remember him saying the word attempt. There you go. So, all right.
And I believe, and if the court would like me to try and find it, because a defendant certainly doesn't have to confess or make a statement for the administration of justice to deter, I believe there's a case that was just recently ruled on that says that is not scorable under OV-19.
There, if I recall the case.
Mr. Harrison just helped me out with it.
All right, Mr. Harrison, go ahead.
It's the Dewar case, 511 MIF at 980. In contrast, a defendant's denial of culpability without more does not slow or prevent a criminal investigation or constitute an effort to do so.
Difference here, I think, is a denial versus a misdirection. And that is, so if a defendant lies to law enforcement that's different than a denial. If the lie or misstatement was an attempt to redirect law enforcement. For instance, Judge, I don't have any guns in my house, but then they look and there's a gun in the house. That's a little bit different. Or, Judge, it wasn't me, it was that guy. And then they go, that's a little bit different because they're trying to actually impact or redirect versus a general denial, is my understanding. So the court will deny the challenge for offense variable 19, although it's a good question. And I do appreciate counsel reviewing the guidelines.
Clarifying the denial, does that mean we're not scoring it?
Yeah.
Okay.
That's okay.
The phrasing and the way it was raised, I didn't understand.
I think my phrasing was perfectly clear. It was wonderfully stated.
I agree. I was just slow enough to not understand it.
That's okay. Mr. Carnes, any other corrections or amendments?
No, Your Honor. Thank you.
Mr. Chair, allocution, and you may address both.
Thank you, Your Honor. That's what I was going to ask. Do believe we have a victim statement. Just want to
do
make
we?
sure.
I do have a written statement.
Does she wish to make a verbal?
She wishes to make a verbal.
Ma'am, you may approach. Your goal is this. If you wish to bring somebody up with you for comfort, that's appropriate. No worries. All right. Your goal is that podium. Before you start to speak, I'm going to ask for you to please state for me your first and last name.
Sandra Valentine.
All right. And Sandra, would you please, I know it's probably common. Is it a common Sandra? That's a yes.
Yes,
Thank you. And Valentine, common spelling?
just like the holiday.
Just like the holiday and the saint who got us, makes us spend money on cards. All right. Thank you, ma'am. What is it you wish to say? You can have someone else read your statement if it helps you.
Okay, she brings it.
She may hold it and I can see it from there.
Do you want me to read it? She
Yeah.
wants me to read it for her.
Okay, ma'am. So let's tell me what your name is.
I'm Trisha.
Tricia?
Trisha, I am her sister.
All right. And your last name, ma'am?
Fast and easy.
Oh, you're going to have to spell that one for me.
B as in boy, A-S-A, N as in Nancy, E-S-E.
All right. Thank you, ma'am. You may.
Okay, so I'm.
I understand.
So she wrote it, so I'm her.
I got it.
On March 31st, 2025, my life as I knew it changed forever. My name is Sandra Valentine, and I'm writing to share the personal impact of the abuse I endured at the hands of Jeffrey Stark. How the crimes committed by Jeffrey Stark had impacted my life and the lives of those close to me. This statement reflects the emotional, physical, financial, and psychological consequences I have experienced and continue to live with. I lived in fear in the home that I lived in, a place that should have been safe. The emotional damage is still unfolding. I am the shell of a person I was. I experienced grief every day and had to have someone with me just to get through the most basic part of life. The unfolding of this includes panic attacks to agoraphobia, nightmares, sleepwalking, and overwhelming sense of distrust that seeps into my daily life. I am in a hypervigilant state and fear that I have PTSD. In the beginning, my memory was suppressed, most likely due to the traumatic events that occurred. My sister was present when I remembered the entire attack assaults. One day, my sister asked, "Why is your neck so badly bruised?" The light bulb came on. I turned my head and rattled. I was beat to the floor, and Jeffrey Stark straddled on top of my chest, keeping my arms down by my knees, strangled me, and said I could kill you. I said I was feeling weaker and weaker as I was in and out of consciousness. Though through flight, but whatever it was, I was able to get my arms loose and grab and squeeze his arms to loosen the grip, which happened. At that time, Jeffrey ran to the bathroom, which I stomach crawled to get my phone. Jeffrey Stark returned, but with a pistol shoved in my face, between my eyes. It was then I raised my phone up and said, 911 is on their way. I lied. They really weren't. Jeffrey Stark then ran to the bathroom, and I ran outside and called 911. That night became suppressed for over 2 weeks. Physically, I suffered multiple injuries to include bruises, hematoma, concussion, subcutaneous contusions. To date, I'm still experiencing headaches daily and ring in my right ear, and of course, never-ending fear. My family has suffered immensely. My children are struggling at the sight of their mother after the assault was traumatizing to them. The thoughts of them attending my funeral still haunt us as a family. Through research, when you are strangled, the intent is to kill. I became a prisoner under the battered women syndrome. I left numerous times, but went back numerous times. I was scared to stay, scared to leave. I was crippled in a toxic environment, and now I am traumatized. My daily life has been altered in ways I never anticipated. My fear is that I may have to relocate to a different city or even state. I avoid certain places, situations that remind me of the crime. I respectfully ask the court to consider these impacts when determining an appropriate sentence. I fear for my safety and the safety of others, as Jeffrey Stark is not held fully accountable. Thank you for taking the time to consider my statement, for allowing my voice to be heard in the process. Sincerely, Sandra Valentine.
Yes, ma'am. You said there was a photograph sorry, what else? Is there additional statement or those photographs?
There's photographs.
All right.
I can, should I?
Hold on. Madam Clerk's going to come gather those from you. Thank you.
I believe the top one was 4 weeks after.
All right. So there are 2 photographs. Sorry, take that back. 3 photographs. And I see that one of them has a note that says month after.
Yeah.
Okay. I'm going to have Madam Clerk bring those on to council. Thanks. Ma'am, did you take those photographs?
No.
From whom did you obtain those photographs?
Sure.
All right. And I see Miss Valentine had left the courtroom, but has now returned. Miss Valentine, would you please tell me when those photographs were taken and by whom? Okay.
I sent them to Super Guilty.
Okay. Were these Mr. Carnes part of the file? Thank you, Madam Clerk. I'll take them.
Not initially, Your Honor. They were part of the second warrant one.
So they were part of a police report, which means my question is were they provided to defense, Mr. Cherry?
They were, Your Honor.
All right. Thank you. All right. Thank you, ma'am. You may take a seat. All right. Thank you. The court is sua sponte going to raise a couple issues here because the court can make findings based upon facts that are presented here, and the court offense variable number 4 wasn't scored for serious psychological injury. This court's going to score 10 points for offense variable number 4. At least I'm going to raise it up for counsel's challenge in just a moment. Also, there was no scoring under offense variable 10 for exploitation of a vulnerable victim. And this court is going to score 10 points because of the abuse of a domestic relationship. Apparently was quite ongoing. All right. Mr. Terry, any response, or I assume there's going to be an objection. I'm allowing you to make that now. Thank you.
I'd like to take the court back to the plea hearing
Sure.
back on, I believe it was shortly after April 8th. I don't remember the exact date of the plea, and it really doesn't matter. At that time, the court may remember that both the prosecutor and I represented to the court that, because the court inquired when we were entering the plea, how this assault began, right? What was going on? And even the PSI report outlines the argument began when Ms. Valentine initiated it over whether or not Mr. Stark was seeing another woman or talking to other women on Facebook. It then turned into a mutual altercation. And at the time, the prosecutor was even contemplating issuing charges against Ms. Valentine. There was also a destroyed cell phone of Mr. Stark's, which it could not be established exactly who broke the cell phone, whether it was Ms. Valentine or Mr. Stark. However, this conviction in the 2025 case arose because Mr. Stark escalated that mutual assault by raising a gun and therefore committing the attempted felonious assault. And so I think that the scoring of OB10 mischaracterizes the
Would you like to present evidence? I don't care what the attorneys tell me, because I'm quite confident that the rules all tell me that whatever the attorneys tell me is not evidence. I now have evidence that the prosecution has brought up here through the victim's advocate, and the victim, she was able to testify and provide statements, which the law allows, and she has now characterized it much differently, which means I can now make a finding that she was physically abused, that she was psychologically injured. And now, by the way, I will note, let's think this all the way through. Even if I do score it, because you guys have cut this deal for an attempted, we're at an H grid. The offense variables won't actually change the scoring. So I'll tell you what, I won't change the scoring, but I sure as heck am going to reference it and use it as my sentencing causes. I now have testimony, and I will base my sentence on what she said, not how it was characterized by the defense counsel or the prosecutor, or based necessarily even the defendant. I now have that this caused serious psychological injury and physical harm. All right, I won't score it. Thank you. but I'm going to reference it and it's going to be used as a basis for my sentence. Thank you. All right, I won't score it. We'll leave it alone. It's still at OB 20 points, which is the max for a class 8. All right. Allocution, Mr. Cherry.
Your Honor, just prior to December of 2021, and I'm beginning with the 2024 file just so I can move in a corresponding manner. Mr. Stark divorced from his ex-wife and didn't seek any type of treatment, didn't get any help, didn't pursue the mental health issues that he needed to at that time. We then see one prior retail fraud in December of 2021 on Christmas Day. We then fast forward to his relationship with Ms. Valentine, which began in 2022, where Mr. Stark began using cocaine and never sought treatment for those ongoing issues going all the way back to after his divorce. Mr. Stark was ultimately arrested and charged with OWI high BAC in possession of cocaine less than 25 grams in the 2024 file. During that course of that case, in addition to the jail credit that he had, he also went to rehab for 30 days. And I'm going to deal with this case separately because I think it's very different than the other case. Because even when he's arrested for the felonious assault, much to many of our surprise at the hearing when we entered the plea, there was no alcohol or drugs involved. And so I point that out to say one of several demons was dealt with on that day. He had been to rehab, he was sober, he was maintaining his sobriety, making those good decisions after going to DeCoste home. I think that in the 2024 file, a time served taking into account the rehab that he did makes sense. We then come to the felonious assault, which has been very differently characterized for the court today than it was in the police report, in the PSI.
Was this so the domestic the assault portion was a plea though, correct?
Correct.
All right. Okay. You may continue.
Yeah. And he pled to the felonious assault. Again, we went through a thorough examination at that time of what the altercation was, and ultimately what the conviction was for pointing a gun at Miss Valentine. And at that time, his guilty plea was to raising the gun for a brief moment in time and then lowering it. Don't have anything else to say about Ms. Valentine's statement here today, other than it is different than the police report, the PSI, and the representations made by the prosecution and I, which is what it is. Mr. Stark has appeared for court at all times. He ultimately was cooperative with the police, even at the scene. He was interviewed. It did take 2 times, but he was cooperative and told them what had happened. His story was corroborated by Ms. Valentine's interview at the time, which is the same as the interview that is in the PSI.
The interview, you mean?
The agent's description.
Okay. All right.
That description is corroborated by both Miss Valentine and Mr. Stark at the scene at the time of the investigation.
So the fact where it says here, so the statement here is that the argument escalated. He became physical. He charged at her several times and struck her in the face and pushed her back on the couch, and had a large swollen welt on her cheek. And so it wasn't just a push. It says in here there was a physical assault too. I just want to make sure I'm correct. So it wasn't just a push. It wasn't just a point. It was that he beat her. Okay, keep going.
That is correct, although I will point out for the court, that's a different story than what you heard from Ms. Valentine here today when she
Right.
said he pushed her onto the ground, straddled her chest, things like that, strangled her.
But
None of that is in that statement.
Yeah, you guys want to challenge it, you're more than welcome to ask for, to present different evidence or, but that's okay. All right, keep going, whatever you want.
Thank you, Your Honor.
All right, thank you. Mr. Carnes?
Thank you, Your Honor. Last week, I recall you mentioning the cycle of domestic violence.
Mhm.
And I really think that's at play here. And this case was resolved as it was on information that's different. However, I think some of the undisputed facts are that the defendant pointed a gun at Ms. Valentine and she has suffered tremendously as a result of that. And I'm just going to focus on what the plea was. I think that's fair to all parties. But she has suffered, and it sounds like she's suffered for years and is finally coming to terms with it. And I understand she's making some positive steps. The disturbing thing to me about this case is that the defendant pointed a gun at Ms. Valentine and then continued speaking with her and was very nonchalant about all this when he was violating his bond conditions by speaking with her about it.
How did he violate his bond condition?
He spoke with her at the Wexford County Jail. This is the hearing we had last week where he was found in contempt. Thank you. And that is disturbing for that reason, as well as the fact that he doesn't seem to be showing any remorse when speaking to her. I do think it's appropriate to sentence him to the top end of the guideline range here. I do note this is a violent crime, so we're not in the typical reasonable cause, although I think there's plenty of reasonable cause factors to sentence him to jail regardless, including violating bond. And as I just said, the lack of remorse. I would ask for an 11-month jail sentence in the file, the 25 file, as well as 3 years probation with a no contact order to continue. I'll leave sentencing completely in the court's discretion on the other file. Thank you.
Stark, you have the right to make a statement. Is there anything you wish to say before the court issues a sentence?
Not really. I was just a relationship defending myself, and I'm sorry for her. I don't know what to say.
Okay, well, no, that's important. Hold on, that's really important. You've now just taken your guilty plea and you've now inserted to me that you were defending yourself, which means that you are challenging your plea. I'm going to ask you, hold on, because of now of your statement, what I have to be worried about is, did I take a knowing, intentionally, and voluntary waiver? And I'm not pointing the finger at Mr. Cherry, but maybe you didn't understand his advice. So now I'm going to ask you, do you wish to withdraw your plea and go to trial? Because that's what you just said to me. All right, thank you. Then I'm just going to interpret that as an offhanded comment. Yes, Mr. Cherry?
Your Honor may recall the exact statement made by Mr. Stark, and that's why the court inquired about the aiming of the gun.
Yeah.
And that he had no reason to escalate it.
I got
And
it.
so that's how we established the factual background.
So here's what I'm taking. Mr. Stark, I don't believe you. Okay. I think you overindulged in alcohol and you like to beat the person that you're living with.
I wasn't.
Oh, hold on.
No, I wasn't.
No.
I wasn't drunk though.
Okay.
Was, but
okay, no, hold on.
I'm sorry.
This is my time. If you do that again and you want to take your little smile and give me that attitude, you can. I will take the time. I will adjourn your sentence. I'll send you back to the jail on a contempt. If you do that one more time, you may not have been drunk at the time, but you lied to law enforcement. You beat her. You caused bruises. and you pointed a loaded gun with a round in the chamber. Then when the police got there, you lie. And then when the police got there, you pointed the finger to her and said that it was her fault. See, one of the challenges that I get as a judge, and that I think counsel often get confused, is when the court takes a plea, I go through a process and procedure. I do not. No judge gets to say, I think this plea is a great idea, or I think this plea is a bad plea, especially because at that time, I do not know the facts of the case until I get a report like this. It is at this moment in time, at sentencing, the case is then given to the court. And it's at this time I get to apply my discretion. I know attorneys might, and I'm not trying to pick on these attorneys because it's not their fault. They often think, Judge, this is my case, my ownership, but not anymore. It is now my case. By the way, if anybody wishes to challenge, and this is what I opened up a moment ago, if you all wish to challenge the contents and the accuracy of a PSI, you can do so. And I opened it up and said, if you would like to challenge it, you can. The defense didn't, which is probably a good choice because they have foregone that process and procedure. I have allowed both parties to now give me the case for my exercise of judicial discretion. I don't care if what her statement does or doesn't compare to the state. No one gave it to me. I gave you all the opportunity. You all let it go by. It's now my case. That right there was what we needed to see. And by the way, if this was in the police report, like I asked, I don't care if the parties told me that what they try to sugarcoat it and make it sound differently. I didn't get to see that picture. I have now, Mr. Stark. I now have her statement here today. No one challenged it. That means that statement I find by preponderance of the evidence, which is allowed under the law, I get to accept, and I do. I find that the sentencing guidelines, by the way, when I made the decision not to score those extra points, I get to, pursuant to MCL 769-34, now make the statement that the guidelines are inadequate. So now, Mr. Stapleton, there are a few other changes on the PSI for the misdemeanor file. First, we need to change the sentencing date, of course. Number 2, on the bottom of page 1, what did everyone forget to add? In addition to alcohol, cocaine. This is not just an incident where the defendant is drunk with a .196. There's also cocaine. And when I looked at this file, circle the .196. I know he had a PBT, but that's inadmissible. He had a .196 blood alcohol level. It appears to be that the defendant is suffering from substance use issue. I'll note that in the past, in the 2022 case, that occurred while he was on bond. So he had a retail fraud charge in 2021. And then while he was on bond, within 2 months, he picked up a charge, but I'll note that it was dismissed. Well, actually, I'm not going to count that. But now I look at the current case, and I'm quite concerned here. Plus, I note that the defendant violated the bond in the other case in the 2025, which makes me wonder if he is going to be able to comply. Well, I'm going to tell you, in that particular file, I'm going to make this sentence pretty simple. In that file, the court assesses 2 $50 state minimum fees, 1 $75 crime victims' right fund fee, There is no attorney fee since Mr. Cherry has been retained. There will be, however, a court cost of $150. I'm going to add and these are just fines and costs. I'm going to add a $500 fine. And were there any other fees in that file? It seems like there should be, because it should be. What's your prosecution fee, Mr. Carnes?
$100, Your Honor. I'd also request a $200 restitution to the Michigan State Police.
We will establish those two. So it's $100 to prosecutors and $200 to the Michigan State Police for their response and prosecution of the case pursuant to the law. And I've already established the fines and costs. The court will place the defendant upon a period of probation for 18 months. The court adopts the terms and conditions for probation that are listed on CFJ 145, pages 2 and 3. Court finds, again, that those terms and conditions are well suited for this particular kind of case involving controlled substances. As to any period of confinement, the court is going to sentence the day for both counts to 68 days with 68 days of credit. Now, as to the other file, let's go ahead and comment a little bit further. I have a conflict here. I'm being told, and I don't think Mr. Cherry is saying this, and I'm not blaming him. He's doing a great job today advocating on behalf of his client. I'll note here, he didn't take much accountability. No, he doesn't have to. He was blaming a lot of it on her. As far as every class I've ever taken, that's 100% what I expect from a domestic abuse. Then lied to law enforcement, but thankfully they found the gun, and the gun was a 9mm with a round in the chamber. You pointed the gun at her with a round in the chamber. That means you had to put it into the chamber. I would really have liked to know, when did you ratchet it and put it into the chamber? Oh, and it was a hollow point round. This concept of smiling and pointing the finger at her only offends this court. Not personally, but professionally. You pointed with hollow points and a round in the chamber. Good Lord. I find that the sentencing guidelines do not adequately account for the offense. I take a look also at the benefit that you've received from the reduction of the charge. I don't blame anybody for that at all. However, the court finds that the guidelines, again, are inadequate. But thankfully, they are only suggestion. They are a tool for the court. I find that the conduct was substantially compelling to go above the guidelines, and the court sentences the defendant to 365 days in the county jail, and the court awards the defendant 37 days of credit. The court places the defendant upon a period of probation for 36 months. I adopt all the terms and conditions that are listed on CFJ 145, pages 2 and 3. I find that they are well suited for rehabilitative purposes, considering the nature of the offenses and all the factors that I've discussed today on the record. Mr. Stapleton, have I missed anything?
Your Honor, I've neglected to put in no contact condition.
Oh, if the court will direct the probation or office to, when it prepares the order for probation, to have no contact.
Okay.
Also, while I failed to mention it, the fact that the defendant kept violating his bond by violating this court's order by having contact with a domestic violence victim definitely supports the sentence given by the court. Thank you. Anything further, Mr. Carnes?
No, Your Honor, thank you.
Mr. Chair.
Your Honor, just confirming the sentences of the
Oh, yes. You run concurrent with one another. Thank you.